This is Rahul Reddy. Along with me is my business partner, Rebecca Chen. We do have a guest speaker today. That's Prakash Khatri. He is the first ombudsman for the USCIS. He is the one who was, according to me, in charge of bringing the processing time of the 485 applications from 4.5 years to all the way to 6 months. And at his time, when he was the ombudsman for the USCIS, the entire priority dates were become current in July 2007. There are many accomplishments he has done, but these are some of the things that I want to point out. Prakash, if somebody wants to contact you and you want to discuss their issues, how can they get in touch with you?
They can get in touch with me by calling me at 202-470-0431 or accessing my website at khatrilaw.com. That's KHATRILAW.com. And they can also email me at prakash@khatrilaw.com.
And the links have been provided at the bottom, guys. If you want to contact Prakash Khatri, you can contact the website, and the email is there in the video link. Rebecca?
Yes, so thank you so much, Prakash, for joining us. We're looking forward to your valuable insight. So a big question that we're considering right now is, given the current situation, so the State Department is required to allocate visa numbers based on demand for immigrant visas, either at the consulate or at USCIS. If there are too many visa requests, if there are too many applications, then they're supposed to set the priority date such that the demand matches the number of visa numbers available. However, today the situation is quite different. There are not immigrant visas being issued at consulates, and we know that USCIS is not approving applications at the level that they should be. So given that situation, why do you think the State Department is not making priority dates current?
Well, that is in the old sense, the $100,000 question, today the $1 million question. And basically what is happening is that somehow the State Department is interpreting the law to be that USCIS tells it what the demand is. And I frankly do not understand how the law can be circumvented in that way. But my understanding of the law is if there is not sufficient demand for the visa numbers, then USCIS is obligated, the State Department is obligated to open up the visa numbers. In this particular situation, it's interesting because there's only one set of country nationals that are greatly impacted. There's a couple of others, China in particular, that has some impact, but mostly India is impacted. And the Indian nationals that have been impacted have really been impacted by the failure over many, many years of USCIS not processing sufficient numbers in the early days, thereby losing maybe 200,000 visa numbers in the early days. And I think in 2007, I actually listed the total number of employment-based visas that had been lost as of that time. And if those had been recaptured many years back, we would have actually had quite a substantial forward movement of Indian visa numbers. Now, that's not to say that Indian visa numbers would be current, but we wouldn't be in the backlog situation we are. And today, with the new miracle that's happened, literally it is a miracle, in a weird kind of way, the pandemic caused a once-in-a-lifetime situation where over 100 and some odd thousand visas were not used in the family-based visa category in fiscal year 2020. And in 2021, we're going to have maybe 160,000 additional visa numbers that will become available just by consulates not using the family-based visa numbers, because most of the consular posts have been closed, and the ones that have opened are now prioritizing immediate relative family members over preference family members, which they rightfully should do. And that is resulting in substantial lack of usage of the family-based visa numbers. Now, the formula that the statute dictates is a very interesting formula. In most years, what happens is family-based visa numbers by immediate relatives are so substantially higher that they then are subtracted out of unused family-based visa numbers. And so in the family-based area, this is a once-in-a-lifetime event where it didn't happen, and thus we were able to get family-based unused visa numbers to come into play here. And that is something that should not be missed. And this year, it looks like, according to Charlie's July visa bulletin discussion a few days ago, he seems to be suggesting that as many as 100,000 visa numbers will be unused by USCIS from the employment-based category, which is totally, totally unacceptable. What really is so amazing about this whole thing is that USCIS is processing EADs, is processing I-131s, is processing H1, H4, L1, L2, and L2 EADs and H4 EADs for people, where all of those petitions would not be needed to be processed if they only focused all of those resources on the 485s that are pending. If they simply did that in much less time than they are wasting on all of these other petitions and applications, they could be focused on processing 100,000 visa numbers. They can do that in the next month and use up all of the visa numbers. This is exactly what happened in 2007, when USCIS in our interagency meetings in May of 2007 indicated that there was no possible way in which they would be able to, under any circumstance, process the 40 or 50,000 visa numbers that were still available.
I want to get to the 2007 issue, a little bit more clarity
Sure.
from you, a little bit more detailed, Prakash. So
Sure.
what you're essentially telling is that if they would just allocate the resources directly to the 485, we don't need these EADs, we don't need these advanced paroles, we don't need H-1B extensions, we don't need H-4 extension. Give them their damn green cards, get them out of the way.
Right.
That's what. Now you're telling that this is what exactly happened in 2007. Now I want to show the visa bulletin to the people, the visa bulletin that's in 2007, how it existed. Now Charlie, in his August visa bulletin comments, though, he said it cannot be done. The visa bulletin cannot be current like the way what happened in 2007. He said that at that time, there were not enough 485 applications that were there to be adjudicated. That's the reason why he made it current. That's what he said in the visa bulletin of the July 2007. Then, but before the applications had been filed on July 2nd, he took all the visa bulletins back, though. Now, you were the ombudsman at that point of time.
Yes.
What happened at the time which made the visa bulletin current at that point of time? What happened? Because you were on the other side at that point of time. Well, tactically, ombudsman is neither is USCIS employee nor a private person like us, but you're in between, but you're in charge at the time. What happened?
Well, as I explained in some detail, not great detail, in my 2007 CIS Ombudsman's report to Congress, what transpired in these interagency meetings was a very interesting series of discussions every month from about December of 2006 until May of 2007. Every month, my simple question to USCIS was, how many employment-based green card petitions, green card applications, the 485 applications, have you processed? And how many do you have in the queue? Firstly, they could not answer how many they had in the queue. But over a period of time, they were able to suggest that they had a sufficient number in queue, but they were unable to process that number by September 30th. And so in the May meeting, which preceded the late May meeting, which was right after the June visa bulletin was announced on May 10th, I asked a simple question. I asked USCIS, are you going to be able to process the 40 or 50,000 visa numbers that need to be processed in order for all of the employment-based visas to be used up? And they responded equivocally, no, we will not be able to because of our prioritization of work. And so, in effect, what they said, and Charlie was at those meetings, was that this was not going to be possible. And so I basically turned to Charlie after months of saying, don't do that to Charlie, because of the potential impact on USCIS. I said, do you even have a choice? And the answer I got back was that there was no choice in that case, because USCIS had clearly indicated they were not going to use all of the visa numbers. And so Charlie Oppenheim, who is from the Department of State, was in effect forced to bring current all of the visa priority dates because there was no demand. There wasn't sufficient demand. And the law states that if there's not sufficient demand, he needs to bring up the visa numbers to current in order to create that demand. And so that is what should be happening this time. What amazes me is the law has not changed between 2007 and now. And so I am at a loss for understanding what the interpretation is that these folks are basing their inability to do so on. And I would really, really suggest that they come up with very clear definitions that are different from what the law stated then versus what the law is now. And from what I can recall, the law hasn't changed. So unless they can show something different there, and there may have been a law change that I am unaware of. So I'm not suggesting that, there is no difference.
No, Prakash, there hasn't been any law change at all. It's been the same law, what has been there about the visa bulletin. We still have the per country limit. We still have that excess green cards that are not, that the other countries don't use, will go to the oversubscribed country. It's the same thing what it was there in 2007. Yes, before 2000, the law was different. That if the oversubscribed country will not get the wastage green cards or unused green cards. Right now, from 2001 onwards, if I'm recollected, is that the excess green cards will be given to the overused countries. Everything remained the same.
Right.
Charlie said that in 2007, he didn't had enough cases in the pipeline. That's what he made a statement. When we questioned him, 800 emails were being sent. Most of it we've been drafted by us, and we put it in there. 800 emails were being sent to him. He answered the question at that time saying that in July or in June of 2007, though, he didn't had enough cases in the pipeline. That's what he wanted, he stated. Can you go to the next slide page? Then if you look into July, you guys made the priority date current, as you are aware of.
So,
and on July 2nd, though, you guys took it back.
Right.
And within that 16 days, the State Department says that 60,000 green cards were been approved. This link, I am not creating it, guys. If anybody wants to, I have provided the link at the bottom. So explain that, how did they got all these numbers within the 15 days of 1.5 months? And how did they adjudicate it to 60,000 green cards, though?
Now, there are a couple of things that were happening, not dissimilar to what is happening today, but in reverse. What was happening at that point was in August of 2007, USCIS was going to have a new fee rule. The new fee rule was intended to connect or disconnect the I-485 from the I-131 and I-765, so that actually not disconnect, but to connect them all together so that there would be one single fee. And the fee was supposed to be substantially higher than the existing fee. So USCIS obviously is a fee-based agency, and one of the things that I want to clarify right off the bat here is that USCIS has a phenomenal group of employees. They are charged with a process that Congress created that prevents them from doing logical, common sense things. And when they do those logical, common sense things, what ends up happening is they suddenly will have a deficit in their revenue streams. And they have to manage this in a very, very convoluted way. And God bless those leaders at USCIS who have to manage this really complex process. And so what ends up happening is between June 10th, when Charlie announced the current status of all of the visa priority dates, and 20 days later, USCIS realized that, oh my goodness, this is happening July 1st, not August 1st. And they, took the resources from everywhere else and suspended weekends and evenings and everything else, and put entire groups of staff on the processing lines to process as many of the pending green card applications that they had. And within 20 days, they were able to use up all 60,000 or so additional visa numbers. And to the green card beneficiaries, they were very, very fortunate. But what ended up happening was that this was a weird situation where it was announced on June 10th. And so many hundreds of thousands of applicants and their lawyers and others prepared all of the petitions and applications to file as of July 1st. And all of a sudden, all of that stopped. And so there was a puzzling set of all kinds of issues going on, and I was in the middle of all of that, and we were able to work out a situation where USCIS would be able to maintain the old fee structure, which allowed for all of those people that filed in that August period,
before August 16th,
all under the old fee rule. And what I showed through various charts and things was that USCIS would really benefit long-term for many, many years if they were to do it under the old fee rule, because this
year in advance for all
new
we
fee
have to
rule
pay
was only
fees.
going to be a one-time fee of the I-485, and then they would be stuck for many, many years issuing EADs and advanced paroles, as they are today, without a fee. And so there was going to be no fee generation. And for a fee-based agency, that was a disaster in the making. And so through a series of different meetings with the secretary and the director or an acting director of USCIS and all others, we were able to come up with a process to do what happened in late July, where we opened up for an additional 30-day period the priority dates to allow all those that were supposed to file to file. Now, there were threats of lawsuits. There were all kinds of issues going on. And it just seemed like the fair thing to do at that time. And everyone seemed to agree at the department and outside the department. And so this happened. My concern this time around is that USCIS will actually be hurt greatly if they do not process the 100,000 visa numbers and shut the gates, so-called, to prevent additional filers from filing. Because by statute, my reading, and again, I'm not suggesting that there's not some thing in the law that doesn't allow it, but under my reading, USCIS should be forced into processing the I-485s and forego processing the I-131s, the I-765s, the H-1s, L-1 extensions for all of those adjustment applicants. And they have a sufficient number of eligible people that are already in the process. Many have been waiting since 2008, 2009, 2010, all of whom should be eligible now for these visas that are a one-time opportunity. And so I would really commend to USCIS and to the State Department that they use this opportunity to undo a very, very negative part of our history, where we have groups of employees who stand next to other employees who are from a country other than India, and all of a sudden they have green cards, and these folks from India have to wait for many, many, many years to come.
That's another question,
There's a
Prakash.
national origin discrimination there.
Yeah, I mean, right now, if they don't give these green cards and they don't make it current for the Indian nationals, though, we're wasting the 250,000 green cards. And the other nationals, they're not getting affected. It's either Indian nationals to a greater extent, to some extent Chinese national, mainland Chinese nationals. So I think so. Yeah, it's going to be discrimination suit. Now, of course, while you and our team is working on litigation, what to do, and we'll come up with some plan on the litigation. But while this is going on, what can the applicants do right now? If they have already filed the adjustment of status, or if they are waiting for the priority date to be current, what can they do? I mean, neither they are giving the green cards, nor they're making the current. Of course, we have drafted a letter and put it in the link, guys, at the bottom, where you can contact the congressman, so that this discrimination doesn't happen, and the USCIS does it work what is being done, or force the State Department to make everything current. What other suggestions do you tell, Prakash, for these people?
Well, I think there's a number of suggestions. The challenge is that we have literally a month and a half until August, at the end of August, to change things. And frankly, we only have about 15 to 20 days until August 10th, when the Department of State will announce their September visa numbers. And so it's really, really imperative on all those lawyers and their clients listening today to really come up with a strategy to make sure that USCIS, but more importantly, the State Department, is forced into into making current the visa numbers, or USCIS is forced into using up these unused visa numbers. My recommendation from an overall governmental standpoint for the betterment of government is that USCIS do what it should do, and that is to forego processing EAD applications and all the other ancillary applications, the I-765s, the 131s, the H4s, the I-539s for H4s and L2s, and the I-129 extensions for all of those that have filed adjustment of status applications already. I am not suggesting that H1s and H4s who have current pending applications but do not have adjustments of status be slowed down. All I am saying is, let's take off the table all of these ancillary applications that are connected to the current I-485s that are pending. And USCIS will benefit in two ways. One, USCIS will save having to process many hundreds of thousands of hours worth of these applications. They have already received the fees. None of the applicants are going to demand that the fees be returned for USCIS not processing these applications. In fact, the applicants will save millions and millions of dollars cumulatively in all of the time and effort, but more importantly, many families, deserving families, at a time when you have this miracle that happens in the middle of a pandemic. Let's make use of this. Let's not waste it. And let's get 250,000 deserving people and families combined get these visas. It's not a lot to ask. All we're asking is that the agency reallocate the resources. We're not asking the agency to create new resources. They've already got the money. They're actually going to save money by doing this.
I want to tell the audiences that we have prepared the draft letters for the congressmen. We're going to prepare the draft things for the State Department. We know that Charlie commented on these routine emails that he's been getting, but it's a burning question to the people. Combining employment-based and family-based, there are different people compared to us. I mean, there is a different problems for them. But we will draft the emails to be sent to Charlie to question it. We will probably draft a letter to send to the current ombudsman. That will be, so keep watching on our YouTube. We will put all the links so that you can take action from your side, so that things can be done. Now,
Rahul, if I may, on that point though, your drafts are really good and commendable that you do that, but what each applicant should do is take that draft, look at what it contains, and then personalize it so that they don't just copy and paste it. This is an important event. They need to personalize it. They need to send it to the White House. They need to send it to the director of USCIS. They need to send it to the DHS Secretary Mayorkas, who himself was a former director of USCIS. They need to send it to the Ombudsman's office, and they need to send it to their congressional delegation, their entire state congressional delegations, both the senators and their representatives. And they need to make them personal. These are personal letters. And so you can give them some of the details, but they need to be personalized on how they are being impacted. And somebody needs to accumulate these as well. Maybe someone can start up, I think most of these guys are tech folks, so somebody can start up some kind of a blog or some place where they can combine all of these. The question that comes up is obviously when you're putting up too much of your personal information, just be careful on that, not to give too much detail, but ask that the congressional office or whoever contact them for the details.
Thanks for the input. We were only suggesting them to send emails to Congressmen and Charlie, but thanks for the suggestion. We are going to include we're going to include their addresses and provide them in our blogs, which we give a link to them. Prakash, Rebecca, you have any questions?
Sure. So Prakash, you mentioned contacting the USCIS Ombudsman's office, and we saw during your tenure as the Ombudsman, there were a number of advances or improvements in processing just in the employment-based area. I-485 processing times reduced from, I think, 4 years down to 6 months. The EAD AP filing fees that you mentioned were no longer additional on top of the I-485 filing fee. A number of improvements. Since then, we haven't seen the same level, I would say, of advocacy maybe from the Ombudsman's office. Why do you think that is, and how can we get back to that same level of service from the Ombudsman's office?
Well, the Ombudsman's office really, they identify the problems, they make the recommendations, and then hopefully USCIS takes those recommendations and implements them. The Ombudsman's office cannot by themselves do anything. All they are an entity that basically oversees USCIS operations and will talk to the stakeholders, namely the employers that file petitions and the employees and applicants that file the applications. And what they do is they gather together the problems that these folks are having, and then based on what they analyze, the Ombudsman's office then prepares recommendations. Now, obviously, when I came on board in 2003, there was a lot of low-hanging fruit. For my part, I had been in practice for many years, had also worked at Disney for a number of years as their immigration manager, and I had seen from both a corporate and an individual standpoint what impact the old INS had on the service portion of the INS, which today is USCIS. And so when I came on board, I knew exactly where the issues were. I had to then go out and figure out, well, what is USCIS about? What are they doing from the inside? And through over 170 field visits to pretty much every USCIS office, many times over in many cases, like at service centers, I'd spend a number of days with all of their leadership. I was able to understand both from their officials as well as from just the law and the way in which it was being implemented, that USCIS employees are trying really, really hard to do a good job. The problem is that the law prevents them from doing what they should be doing, which is really, really strange. Congress really is to blame here. And I went to Congress on a number of occasions, and every report, I suggested all kinds of changes.
Now, for some reason, though, I don't know about the Ombudsman's office. Is it the office? Sometimes it's a personality that makes a difference, Prakash. Right now, we have an ombudsman that comes from the service itself, from the immigration service. She has a lot of experience within the service, though. So when you grow up within the same system, you don't know from the outside what's going on. And then we have the previous ombudsman that came from the FAIR organization, practically that person want the whole immigration to not give any green cards, not give any non-immigrant visas. I don't know how the person was made ombudsman. So definitely we need somebody like you back there to do this thing.
I want to be very clear. I met with every one of the ombudsmen personally. With the current ombudsman, I've spoken to her a number of times. And, the role of the ombudsman really is to oversee things. And the current ombudsman is highly qualified.
This is how I differ from you. I disagree with you, Prakash, is that when an ombudsman role on other thing is that the ombudsman is neither a USCIS employee nor a private citizen. It's in between. You can correct me if I'm wrong.
Right.
So when the ombudsman is supposed to report to the Congress and suggest to the USCIS, now we have the people from the service itself. They haven't seen outside world. They haven't seen the practice. They haven't spoken with the people who get affected. Aging out kids, people going out of status because of the inefficiency on these people, H4EAD delays, everything is delayed. Now they have implemented, I don't know if you are aware that you must be aware that in July 2017, they started interviewing people, which was not there at the time when you were ombudsman. Actually, if I recall that you removed the interview for the 485, the employment based, and now they put it back in 2017. And they put the biometrics for the H4s, which was unnecessary. So all these things, they have put it as a delay tactic. And you know that last time they introduced a 944. They were asking for 4-year-old kid. The credit score, where am I going to get this credit score for the 4-year-old kid? They're asking the property records of the 4-year-old kid. They have added all these things. And you're telling the ombudsman's office has been very good now? I may have to disagree with you, Prakash.
No, again, please read the ombudsman reports. They are continuing to identify the issues. The ombudsman's office is doing a phenomenal job. And I think Phyllis Colvin, who's the current ombudsman at CIS, the CIS Ombudsman, she will do an amazing job because she was a retired senior officer from USCIS. And more than myself, she has intimate knowledge of the inner workings, and she is going to obviously use all of that to help in the position. And her position is basically to identify problems, to make recommendations. I had a real tough challenge because I had to travel everywhere to figure out what was happening, whereas she has many years of experience coming in. So I think you will see a very positive stance from the current ombudswoman. And the prior ombudsman, likewise, even though she had some connectivity to some of the more conservative organizations that were anti-immigrant, her whole role was, how do I make the system better? And it's not about advocating for changing the law to benefit one group or another. It's just, if we have the law, how do we make it better and make it faster and more efficient? And so for her part, she did that piece of it. I mean, we all take an oath to administer the law, and that's what we end up doing. So I wouldn't be critical unless you saw anything particular in the ombudsman reports that was of concern to you. I think the ombudsman's office does a phenomenal job and will continue to do it. But what they need is input from the applicants, input that's not just, hey, I want my case solved. What they need is for advocates like you to put together a series of cases that you see something going wrong in and say, look, here's what's going wrong. Here's what used to happen. Here's what's wrong. And this is how you can fix it. And if you give them specifics, the Ombudsman's office, which is a team of about 30-odd people, really appreciate those types of solution-based approaches. And law firms are very, very well placed to do that. Many of you individuals out there who are listening today may have friends and relatives that have issues that are very similar, and you may be able to do that and say, look, here's 15 people. All of us have had this problem. None of our other friends and relatives had this problem. Why is this happening? Can you look into it? That would be very helpful.
Thank you very much, Prakash. I will definitely, our team will prepare the things. And what do you think? So we should have the draft well made so that given to the people so they can personally explain, or should we just write on the letterhead sent to the ombudsman on behalf of all the people?
I think, unfortunately, the agency is front-facing to the applicants, and the applicants really are at a loss for understanding how the system works. And as you do these videos and as you do these outreaches that both to your clients but also to the general public that use the services of USCIS, it's invaluable for you and others to really start putting out videos like this and others where you talk about specific issues. And I think you're doing that already in your...
Yeah, and then we're going to draft the letters as you suggest. We'll keep it for the people to use it, and we'll provide the email address and the website where they can put it. Thank you. That's a very good suggestion that you have made. We just were focusing on the congressmen and the State Department. Now, it's a good lesson that we learned from you, Prakash, to contact the ombudsman, and have people present their things, though, not just asking for the individual case assistance, but listening to the problem and telling them, look, please use the numbers so that the backlog is gone, which, it comes once in a blue moon. I mean, once in a lifetime it comes in.
This is one of those phenomenal opportunities, and the White House really needs to look at this and say, gee, this is one of those times when we can mitigate this national origin discrimination that our own equal employment opportunity laws are designed to prevent. And yet, all these years, we haven't been able to do it, and we have this one golden opportunity. Why can't we get our executive branch agency, USCIS, to do what is right? And they're not going to lose anything. It's not, they're actually going to make money in this process. So why is the agency not doing it? And that's what the White House needs to really do, and the Department of Homeland Security needs to do. Those are the two folks that can influence and compel USCIS to do the right thing. In addition, obviously, the federal courts can do that as well, because I think to some extent, the Inspector General, the Government Accountability Office, the GAO, those are folks that also can do that. And the congressional offices can ask the Congressional Research Service to do its own research and provide members of Congress with their analysis of this. And I think that things that we are talking about really need to be brought to the attention of the White House and Congress and the Congressional Research Service and the GAO and the Inspector General, in addition to all those others that I talked about.
Rebecca, you have any questions?
Yes. So one thing that has that we have been wondering is whether you have any insight on what is the communication between the State Department and USCIS concerning how employment-based adjustment of status applications are actually processed? Because based on Mr. Oppenheim's recent statements, it seems like he has been setting the dates with the assumption that the I-485s that are filed could be processed within 6 to 12 months, whereas the posted processing time on the USCIS website is clearly far above that. Where is that disconnect, or how? Where?
There is no real disconnect as much as there is a issue with USCIS. USCIS is really the agency that can make the change. They are obligated in 90 days to process an EAD application.
Oh, come on.
They are obligated by law. They have been failing in that, but even if they just scrapped, once an applicant files, if they just didn't even bother dealing with the I-131, the I-765, and just focused on the 485 and waived the interview for those that it should be waived for, and then for those that they had some concerns about, they could go ahead and interview them. But that would be a very small number. What that will do is multiple things. Firstly, USCIS will benefit by having a reduction in the national security threat that is posed by unscrupulous I-485 filers that today do not get recognized for 13 to 50 months based on their processing times.
Yeah, so they deserve to be denied.
Right. These unscrupulous people need to be denied their I-485s. One of the reasons why there's such a backlog at USCIS of 485s is that there are substantial numbers of people today, much like there were during my time, when we had 3 and 4 year processing times. There were a lot of people taking advantage of the system. They would file bogus I-485s, and then they would get EADs and advanced paroles, but more importantly, just EADs. And for 2 or 3 years, they would continue working. They would establish themselves and get the Social Security cards. They would get bank accounts set up. They would rent homes and all of that, and they would settle in this country. And then eventually USCIS would look at the 485 and they would see, oh, you don't qualify. So then they take away the EAD, but by then the person has a driver's license, has an EAD, has a Social Security card, and has established credit and everything else. And then they start living here. And so if this government and the Biden administration is really interested in reducing fraud and reducing the number of illegals that are taking advantage of the system, and I think they genuinely are interested in that, then one of the first things they should do is look at my 2005-2006 reports to Congress, where I documented the 90-day rapid processing of adjustments of status, which led to a 97% reduction in fraud. 97% reduction in fraud. And the processing times came down to 3 months, as you remember.
I remember that we were going to 485 interviews on a Saturday morning. We were going at 7 o'clock in the evening, 6 o'clock in the morning. I remember that when you were the ombudsman. And one request we had at that time is don't process the green cards in 3 months. One of the reasons why we had that request at that time, Prakash, was that especially when married couple, we want to show them like a couple, they're living together. We didn't have enough documentation, living together documents. That was a problem. 3 months green card.
Well, but remember, the 3 month green card was a conditional green card. The problem with 3 and 4 year processing is that someone can defraud the agency by just continuing to say they are married and act like they're married when in fact they're not. And usually when the person gets the green card, their conditional green card, they do get divorced and separated. And then FDNS is there. They can then do the investigations with the U.S. citizen spouse and take care of all of that fraud. But today, that's not possible.
3 months green card? That used to be there when you were there? Oh, let me tell you one thing, Prakash. 3 months green card, let me tell you one thing. The applications we filed in October of 2020, they took 4 months to open and give a receipt notice. Some of them 5 months. We were being fearful. What if the check has been more than 6 months? Maybe the check will get denied.
No, I want to be sure that we balance this, because USCIS did have the same problem we all had. That was a pandemic. And so I don't know about how you would want your cases to be processed, but you certainly don't want people at home in insecure homes to be opening up your files and processing them there. And so USCIS had this lag time to try and get everything together to where they didn't have those issues. And so, they are now coming out of it, and I think they will, but we need to keep the pressure on USCIS, because it's imperative that these 250,000 or 300,000 extra visas be utilized for the right purpose, and also reduce the discrimination against one national origin group that are highly paid, highly educated, and deserving of a green card. More than, everyone deserves a green card, but more than any other group, they are a highly educated, highly paid contributor, tax-paying contributor to this country. And there should be no reason why this should not happen. And the White House really should take this up tomorrow and get a task force together and clean up this mess. There's no reason why 100,000 people should not be getting their green cards where they've been waiting for so many years, deserving. There's been so much legislation attempted, but Congress, the do-nothing Congress, has not been able to do anything. I mean, President Biden knows that. This is one time where the Biden administration doesn't need Congress. They can do this without Congress. And so I urge you to contact the White House. The White House is where you need to focus, and the Department of Homeland Security is where you need to focus with Ali Mayorkas, because those are the two people that can make this happen within the next 45 days. And it has to happen. You have to have it happen.
I have a big criticism about you personally, Prakash, on what you did. Because what you tried to do, I understand, but I don't know. I don't know if it contributed to the negative effect. You are the big judge for it. In the filing fees, though, when you were the ombudsman, based on your suggestions, though, you removed the filing fees for the EAD and advance parole. That definitely saved millions and millions of dollars to a lot of people, though. And not only that, previously they used to give EAD and advance parole for only 1 year. So every time we have to pay the fees, they used to renew only for 1 year. Since you removed at the time, because of your recommendation, the fees was been removed. They're giving, of course, 2 years of the EAD and 2 years advance parole. At the same time, could that be a reason why, because the USCIS is going to lose the revenue, the State Department is not moving? If they would have been collecting the EAD and advance parole fees every year, for a family of 4, it may almost go to almost like $4,000 every year. Could it be that's the reason why they're not moving the dates when they're dumping the 100,000 green cards?
I think the way to really address this issue is not to focus on that. We all know that the agency is they don't have the right statute. They are a fee-based agency that are expected to operate like an appropriated agency. They should really become an appropriated agency, and then both Congress and the department can hold them accountable. Today, they're like the Postal Service. They are expected to create their own revenue. But 2 years before they create the revenue, they're expected to give to Congress a budget to say, hey, we are going to be spending this much 2 years from now, and so please allocate this amount. Now, if in the interim, they do anything that helps to reduce the volume of cases, reduce the volume of work, there's what's known as a fee rule that requires them to only charge what they are able to show that they actually use. And that's why you have all these RFEs, these nonsensical RFEs, and everything else that comes up, because they have to show that they have enough work to justify what they're charging. And so Congress really needs to fix this. But in the meantime, for this particular event, USCIS needs to be forced by the White House to do what is right, and USCIS is not going to lose any money. They're actually going to reduce dramatically the backlogs, because all of those applications and petitions, 3 people filing today have 12 or 13 applications that they could potentially file, all of which would get wiped out by just processing these 3 applications. And they've already paid for these 13. The I-131, I-765, the H-1, the H-4 extension for their spouse, their child, all of those can be wiped out. And it's just unimaginable that the White House would not use this opportunity to get rid of the backlog very, very quickly in many areas, and also help the employees of USCIS, because they will not be forced into this really bad situation of having to work to do just work that they shouldn't have to do. They should really be looking at applications to see, is this a fraudulent application? No, let's process it. They can't do that.
I'm taking some live questions. There are a lot of people watching. Prakash, they want to ask you a question. I'm not a U.S. citizen. I'm an H-1B. Can I contact the White House congressman, or do I have to be a U.S. citizen or a green card holder to contact the White House?
You don't have to be a green card holder. You just happen to be in the country. The president is the people's president. Anyone under in our territory is somebody that can contact the president, because the president and the executive branch are ultimately responsible for ensuring their health, welfare, and safety in this nation.
Does some of the other questions is, does the DHS has a preference to the family-based green cards over the employment-based green card, because they have the votes, we don't, is some of the questions coming on. I want you to address that.
No, actually, the employment-based folks, when you look at who becomes a citizen faster once they are permanent residents, the employment-based folks tend to become citizens much, much faster than family-based. And so, there should be no reason why that would matter.
Now, Charlie has said that he is not going to make the dates current.
Right.
How can we change that? That's a question coming out.
Well, you can change it by litigation. You can change it by having the White House and the Department of Homeland Security force USCIS to process enough visas. It may still not become current, but at least all of the visa numbers will be used up. And that is the best case scenario. Obviously, for those waiting for the green card or to file for the green card for the 485, if USCIS is unable to process, then the law, in my opinion, states that the State Department has to make current the visa bulletin. And so all of these people should be entitled to file. And, there's no reason why they shouldn't be able to file, because they've been waiting for so many years, and a lot of it, for at least 250,000 people or more, has been because USCIS in the past failed to process sufficient number of employment-based visas, which then get eventually lost under the formula, where if they are not used, they get into the family base, but then they are washed out by the immediate relatives. So it only works one way. When the family base are not used, the preference numbers, and they come to employment base, then there's an opportunity to use them. But when they go back, the 100,000, they're not going to be used by the family base. So don't kid yourself. It's not like, and the law is really weird, and you can read about it in the Immigration and Nationality Act. It's very, very clearly spelled out. And it is just a very, very complicated formula, but I've studied it, and I know that it is, these employment-based visa numbers are not going to be used by a family-based folks.
Rebecca, you have any questions?
So we did see some questions come up during the stream. How exactly can we contact the White House or Ali Mayorkas? Is there public-facing email addresses or writing letters? How is that method of communication actually done?
Well, this is what I would recommend, is that your office put out those public-facing email addresses for the DHS Secretary and the White House, both of which are publicly available.
We'll put them, guys. The Congressmen, we already put it there. We're going to put the White House, DHS Secretary. We are going to also put out the Ombudsman. So if you keep watching the next show, we will have all those things by Tuesday, guys. Anything else that Prakash you want to advise people for?
Well, again, my practice, and I think we didn't really talk about what I do.
Yeah. Prakash, where do you practice?
I practice in Maryland, in Rockville, Maryland, and my practice is really limited to post-filing problems, so that people who have issues that come up after they have filed for example, in employment-based cases, you'll often have situations where you as a lawyer are just having a real tough time with a particular case that's somehow gone off track. And so most of the time, other lawyers will contact my office and say, hey, we would like you to be additional counsel on this and assist this person on this aspect of the case. And I'll gladly do that. So many folks will go to their lawyers and say, hey, look, why can't you contact this lawyer? And now it is not cheap. It does cost quite a bit, but it's well worth it sometimes.
Is it only for the applications filed in the USCIS, or is it also where the CBP and the consulates are involved in it?
CBP, consular issues, and even ICE issues. I've often been contacted when someone's been arrested, and I'll work with their counsel to figure out strategies on what needs to be done next. A year ago, things were a little different. Today, there's a lot more possibilities on folks that do somehow come across the folks at ICE and mistakenly get pulled in, or someone entering at the port of entry that's turned back. I've had many a situation where we've been able to reverse that even after they're returned back. And so those types of things come up, but it's the odd cases. These are not cases that regular attorneys usually involve themselves in. Your office usually will.
We recommend anywhere where we're deadlocked, we're dead end. That's it. Go to Prakash.
Yeah, and that's what I do. So feel free to contact me if you have such a case that's complicated, and maybe an error was made by USCIS, maybe an error was made by the State Department or a consulate, or CBP made an error. Those are all things that my office fixes, gets fixed, through legal channels. But by ensuring that whoever the agency is, the right people at that agency get notified that something went wrong in their system. And I'm more about what went wrong in the system and how do they correct it internally. And that's what I usually focus my practice on.
So Prakash, if I had some issue where, I'm deadlocked, I'm not going anywhere, and if I want to speak with you, how is the process involved?
Well, basically, you can email me at prakash@khatrilaw.com.
Can I make an appointment online with you?
Yes, you can. You can go to my website at khatrilaw.com, and you can, the simplest way is just pay the initial consultation fee and I'll schedule an appointment for you. And that's usually the best way to do it.
I saw that I checked your site online. People can go there, they can block the time and pay the things, and then so that they can give all the information, so that when they can speak with you at a particular given time, which is suitable for you and them. It's online. I saw that. That's good that you're providing these services.
Right. It's a little convoluted, and if you have any problems, just email me and we can schedule it and then advise you on how to pay and everything.
Anything else, Prakash, you want to add?
No, I just hope that everyone listening does focus on getting the word out. And this is really an important issue. It is not an issue that you should sit by on, especially if you are a green card applicant or someone who has not applied for the 485 but is hoping to, because both cases, people, if you've got an I-140 that's been approved and you're waiting for the priority date to come current, the usage of the 100,000 visas will, I can't, when you calculate 7% of 140,000 visas, which is the
10,000
number that is available, these 100,000 visas will mean 10 or 15 years saved for Indian nationals.
Plus 150,000 next year.
And the 150,000 next year will be another 10 or 15 or 20 or 30 years saved for Indian nationals. This is huge. I don't think people understand the magnitude of this. And this is not something to just sit by and say, oh, someone else will do it. You, the individual applicants, need to do something. And you need to do something now. And you need to get riled up, and you need to get to the White House. And you need to, let the White House know that this is a really, really important issue. And they need to get behind it. And the White House can gladly contact me if they have any issues, because I can gladly work with them to figure out what the most efficient solution is. And frankly, today, more so than ever, because USCIS had a fee rule that they were going to implement, which was going to decouple the I-485 from the 765 and 131. And that has been stopped. And so USCIS is actually going to be hurting if they fail to close the gate by processing all the applications. So they need to do this. And USCIS, if there's anyone from USCIS listening, they need to really look at this as a savior for them, the processing of the 100,000 visas. They absolutely need to do it.
Thank you very much, Prakash. We have given the links for the people to write the congressmen. You can use the letter and personalize it and send it to DHS and Ombudsman and other thing. We're going to come up with the proper letters to be sent to the Ombudsman in a different format. Probably that'll be done by Tuesday. You can watch our YouTube and Facebook, and in our links we will provide. But for now, the links have been provided for the congressman's letter at the bottom. The link has been provided for Prakash if you want to make an appointment online. Prakash website is there. Anything else, Rebecca, before we close?
No, thank you very much, Prakash.
And I hope that people will. I hope that people will send emails to let us know whether they appreciated this program or not. Sure. Because I certainly want to hear from people to just know if it helped.
Sure.
Thank you.
Thank you very much for Prakash for coming into this one.
Thank you.